There is one sentence in American legal history that still echoes almost 2 centuries later. In 1857, Chief Justice Roger B. Taney wrote in the Supreme Court's Dred Scott decision that Black people had no rights which the white man was bound to respect. It is widely considered one of the worst Supreme Court rulings ever issued, not simply because it was wrong, but because it attempted to permanently write white supremacy into the Constitution itself. Taney argued that Black Americans, whether free or enslaved, could never truly belong to the political community of the United States. He ruled that Congress had no authority to restrict slavery in the territories and declared that the federal government was obligated to protect slavery rather than limit it. The decision shattered the court's legitimacy, intensified national divisions, and helped push the country towards civil war. Dred Scott remained the law of the land for 11 years before it was overturned by the Civil War and the 14th Amendment. Today, Roger Taney's name survives as a warning, a reminder that the Supreme Court can become an engine of exclusion just as easily as it can become an instrument of justice. And that brings us to Chief Justice John Roberts. At first glance, comparing Roberts to Taney may sound extreme. Roberts speaks in the language of moderation. He presents himself as an institutionalist, a defender of judicial restraint, a guardian of the court's legitimacy. The media often portrays him as the reasonable center between more openly ideological justices. And it is true that Roberts has occasionally broken with the conservative wing of the court. He upheld the Affordable Care Act's individual mandate. He blocked the Trump administration's citizenship question on the census. In one abortion case, he sided against a Louisiana restriction. But those moments created a public image that obscured something much larger. Because while Roberts may move more carefully than some of his colleagues, few figures in modern American law have done more to dismantle the legal infrastructure created to protect Black political power. And unlike Taney, Roberts has done it quietly, methodically, incrementally. The centerpiece of Roberts' constitutional philosophy can be summed up in a single sentence, written by Roberts shortly after joining the bench. The way to stop discrimination on the basis of race is to stop discriminating on the basis of race. To many Americans, that line sounds fair, even noble. But embedded inside it is an argument with enormous consequences, because it treats efforts to address racial inequality as morally equivalent to the discrimination that created that inequality in the first place. But these policies did not emerge in a vacuum. They were created because Black Americans were systematically denied rights for generations. The Voting Rights Act of 1965 was passed after decades of violent voter suppression. John Roberts has spent much of his career trying to weaken those protections, and his campaign began long before he joined the Supreme Court. In the early 1980s, Roberts was a young lawyer in the Reagan Justice Department. Congress was preparing to renew and strengthen the Voting Rights Act, and Roberts opposed expanding Section 2 of the Act to prohibit voting laws with discriminatory effects. Instead, Roberts argued that only intentional discrimination should count. That distinction mattered enormously because proving racist intent is extraordinarily difficult. A law can disproportionately disenfranchise Black voters without lawmakers ever openly admitting racial motives. Congress rejected Roberts' arguments and strengthened the Voting Rights Act anyway. But Roberts never abandoned the project. Decades later, as Chief Justice, he finally had the power to carry it out. In 2013, Roberts wrote the decision that dismantled a core enforcement mechanism of the Voting Rights Act, arguing that federal oversight of states with histories of racial discrimination was no longer necessary. In the years that followed, the court weakened additional voting rights protections and limited challenges to partisan gerrymandering, hollowing out safeguards created during the civil rights era. At the same time, Roberts pursued a parallel project, ending affirmative action. He argued that race-conscious remedies were themselves discriminatory, reframing policies designed to address historical exclusion as violations of equality. That philosophy ultimately ended affirmative action in college admissions and cast doubt on diversity initiatives far beyond universities. And this is where the comparison to Taney becomes harder to ignore. Roger Taney openly declared that Black Americans stood outside the Constitution's protection. John Roberts would never say such a thing. He does not use the language of racial hierarchy. He uses the language of neutrality, but critics argue that the effect can look disturbingly similar. A constitution that refuses to acknowledge systemic racism becomes a constitution incapable of addressing it. A court that treats remedies as discrimination can gradually dismantle the tools designed to combat inequality. And when those protections disappear, power shifts back towards states, institutions, and political systems that have historically excluded Black Americans. Taney tried to freeze racial hierarchy into law through brute force. Roberts has pursued a quieter strategy, not open declarations, but procedural rulings, not explicit exclusion, but a doctrine of color-blindness that insists race can no longer be considered, even when racial disparities remain everywhere visible. The result, critics argue, is a legal system increasingly unwilling to recognize structural inequality at all. His defenders say he is restoring constitutional neutrality. Either way, the consequences are enormous because Supreme Court decisions do not simply interpret the law. They shape who can vote, who gets represented, who gains access to education, and ultimately who belongs at the center of American democracy. Roger Taney's language was blunt enough that history could easily condemn it. John Roberts' approach is more careful, more procedural, more polite. But history does not judge courts only by their rhetoric. It judges them by outcomes. And future generations may look back on this era and see a familiar pattern repeating itself once again. Every time America expands the meaning of equality, another generation of judges emerges to narrow it. The language changes, the legal theories evolve. But the central question remains the same. Who counts and who does not?
One of the most consequential decisions the president makes is his appointment of a justice to the Supreme Court. When a president chooses a justice, he's placing in human hands the authority and majesty of the law. The decisions of the Supreme Court affect the life of every American. And so a nominee to that court must be a person of superb credentials and the highest integrity, a person who will faithfully apply the Constitution and keep our founding promise of equal justice under law.